Hi everyone, and welcome to another Law Society of Yukon webinar. Today's webinar is the changes to the enduring power of attorney. Oh, the forms they are a change. Sorry. This presentation will be a brief overview of the Enduring Power of Attorneys Act, inform will inform lawyers about the recent amendments to the act and introduce introduce the Yukon government's new forms and user guide. Emphasis will be placed on advising clients on the decisions they will need to make will need to be made by individuals making an enduring power of attorney. The enduring power of attorney is one of the most powerful and commonly used legal tools available to individuals, especially given Yukon's aging and affluent population. Even lawyers who not practice in this area will benefit from a knowledge of the basics. Today it's presented by Lenora Morris, whose bio is she is a member of Wyeth's private bar and a solicitor, litigator, and sole practitioner since 2007, whose practice included Yukon estate planning, was called to the Yukon and BC's bar in 2001. This is approved for 1.5 hours of CPD by the Law Society of BC and can be applied to both the 12 hours of mandatory continuing professional legal education in both BC and Yukon. So without further ado, I'll hand it over to Lenore, and Lenore tells me that her preference is for questions to come in as the presentation proceeds. So feel free to pop questions and I will get them to Lenore as soon as conveniently possible. Thank you.
So thanks everybody for appearing. I'm going to see if I can figure this out. There we go. So yeah, I don't mind being interrupted. So if anyone has a question, I think it flows better. People get their questions answered when they ask them. Bruce is going to be looking after that for me, and then he's going to have to interrupt me. Um, I have to start out by saying that this slide that I have up on the screen right now changes to the Enduring Power of Attorney Act. The forms they are changing is the presentation that was advertised. And I offered to do this a few months ago at a point when I thought that the Yukon government would in fact have published forms and user guides by this time. And that turns out not to be true. So I'll give you a bit of background because the amendments are in force. So amendments were made to the Enduring Power of Attorney Act back in 2020, December 2020, almost 5 years ago, and then they were brought into force only this year. But they are in force now as of July 31st, 2025. And that delay from 2020 to 2025 was because the government wanted to have a form and a user guide ready for individuals making the enduring power of attorney without a lawyer. I've mentioned on here the advanced directive form. Some people will be familiar with that. It's also a form of the Yukon government that is almost always completed by individuals on their own without the use of a lawyer. The enduring power of attorney form will be something similar that people can fill out on their own. In the case of the EPOA form, though, finalizing that form and guide has been slow and bumpy. I've been involved in that process, so I bear some responsibility. Having said that, clients still need to make enduring powers of attorney. Currently, we have a bit of a void because we've got this new legislation. We haven't got the form. Lawyers have been, up until July 31st, lawyers had to be involved in making an enduring power of attorney because that was part of the requirement. They're still making them. I'm still making them. And I'm hoping to give you some useful information today about what that entails. So this is what I'm actually going to talk about today is generally the enduring power of attorney. That's our legislation and our tool. What you need to
Lenore, just
by your
one
clients.
moment. I
Sure.
did have one person note that they're having some issues with the audio. It's fine for me, but please,
Oh,
anyone else, let me know if you're having any issues with the audio.
thanks, Bruce. I'm using a laptop that I isn't mine. So I'm not sure if the problem is at my end or not. I'll try to speak maybe a little slower and a little clearer though. So what you should know, lawyers, uh, and I'm going to say at the start that I know that there's 35 people in the seminar last time I checked. So some of those people will never have made an enduring power of attorney for a client and probably never will. Um, some of them are going to be individuals who've made many enduring powers of attorney for clients and are continuing to do so. I assume a fair number of people are here to get their CPD credits, and I respect that. I'm going to operate on the assumption that people haven't done this before. So, for the people who've made 100 of these already, for clients, you'll have to be patient. But I'm going to give the presentation as if this is not something that's part of your regular practice. I do think that it is such an important legal tool that all lawyers should have at least passing familiarity with this. And in this case, what's prompted this particular presentation is the amendments to the Enduring Power of Attorney Act, which came into force in July. However, if you didn't know the act before the changes, then you just need to know what it says now. And that's the presentation I'm giving. Really importantly, one of the changes is that the requirement for a lawyer to witness the signature of the donor, and the donor is the person making the enduring power of attorney, that has been eliminated. Having said that, the legislation's actually become somewhat more complex than it was previously. There's more decisions that need to be made by donors. And in my view, the changes to the acts actually possibly make legal advice more essential even than it was before. The donor needs to make a number of decisions under the amended act, and they have more options. These three things that I have listed here on the screen, the enduring power of attorney, advanced directives, and wills, these are what I would consider to be essential legal planning tools. They are things that people can and must do in advance if they are going to operate. So that's why I've underlined planning tools with respect to them. And they're all things that have a really, really important role in terms of um, making sure that people's decisions are respected and that somebody has authority to make decisions for them. So the enduring power of attorney, in a very general term, is a document where the person, the donor who makes it, authorize somebody else to make financial and property decisions for them. So they appoint an attorney. An advance directive is a similar kind of document. It's made under the Care Consent Act. And for that, the person who's making the document is authorizing, again, somebody else to make decisions for them, in this case, to make healthcare decisions. And then everybody, of course, is familiar with wills made under the Wills Act. The State Administration Act also applies. All of these are documents that people should make, and they should make them in advance. But as I think we know, well, we know that here in the Yukon, close to half of the people who died do not have a will. Everybody should have a will. If they don't, somebody else has to come in and figure it out. The same for these other things. For the enduring power of attorney, it's particularly challenging, and I would argue in some ways it's the most important of these. I say that perhaps surprisingly because if you don't have a will, then the Estate Administration Act lays out a set of rules for what's going to happen when you die. If you don't have an enduring power of attorney and somebody, if you lose mental capacity and somebody needs to be looking after your financial affairs, they actually have to make an application to court and be appointed as a guardian. So what happens if someone does not plan guardianship? Now, guardianship's not the worst thing in the world, but what it is a really expensive thing. If you make an enduring power of attorney, you are choosing somebody to be your representative and giving them authority. The law respects that choice, and we've especially under the new legislation, there's a lot of I'm going to say rules designed to make sure that your attorney is somebody trustworthy and solid, and and so they are given a lot of deference. You make that decision, and that person has authority to act for you. If you didn't make an enduring power of attorney and you lose mental capacity, then somebody has to be to apply to be a guardian for you. And in that case, there's no deference given to them whatsoever, and they have to prove that they are worthy of that appointment. And uh, it's a somewhat onerous, somewhat expensive process and a court process that they will have to go through. So, what is an enduring power of attorney? I'm going to step back. If we take away the word enduring, we have power of attorney. And a power of attorney exists under the common law. It's existed for hundreds of years. The word power just means authority. Attorney in this case does not mean lawyer, it means representative. And so the power of attorney is one person giving authority to another person to act as their representative. So with a power of attorney, a donor authorizes their attorney to act as the donor's representative. Traditionally, the attorney can have no more power than the donor. Therefore, if the donor is incapacitated, the attorney loses power. So a traditional power of attorney creates a principal and agent relationship. If the principal doesn't have authority, then the agent doesn't have authority. And it was recognized some decades ago that this potentially created a gap, that there were people who needed somebody to act for them. They didn't have mental capacity. And so this legislation was brought in. In the Yukon, it was brought in about 30 years ago for the first time. And under that legislation, the enduring power of attorney legislation, the power of attorney can survive a donor's loss of capacity. So that's what the enduring refers to. It's not terminated by the subsequent incapacity of the donor, unlike a traditional power of attorney. And that is written right into the legislation. One of the requirements of an enduring power of attorney is that it says in the document that it will survive any subsequent incapacity by the donor. So Old and New Enduring Power of Attorney Act, I'm not going to spend a lot of time on that. As I've mentioned, I'm assuming that some of the people that are watching this presentation aren't even familiar with the old act. But I will say that the original Enduring Power of Attorney Act was pretty simple. It was based on model legislation enacted across Canada. Subsequently to our enactment 30 some years ago, several different provinces amended their legislation, and eventually the Yukon amended its legislation. That was prompted by a few different things, one of which was abuses by attorneys. I'm sorry to say, I've seen this a lot. When I say that the power of attorney is a powerful legal term, a powerful legal tool, I mean it. And unfortunately, it gives the attorney the right to, well, it gives the attorney the right to step into the shoes of the donor. And typically they're doing that at a point when the donor's lost capacity. So they are particularly vulnerable. And if there are financial abuses by the attorney, then at that point, there's nothing that the donor can do about that. So the new legislation adds a number of protections that are essentially responding to the abuses that have been seen from attorneys. For attorneys, there's now a number of additional duties than they had before, in particular record keeping and reporting requirements. They may have to report to the court, they may have to report to the public guardian and trustee. And that is, I think, really important. For an attorney, they are a trustee and they have to act in the best interest of the donor. I think most people understand that, but unfortunately there have been some exceptions. So the rules have been really tightened up about that. And for attorneys, it's been made much more clear what they are expected to do when they're acting in their role. There's, under the new legislation, there's eligibility requirements both for witnesses and for attorneys. And as I mentioned before, we've eliminated the requirement for a lawyer to witness the execution. And the reason for that elimination was to reduce the barrier to making an enduring power of attorney. There's obviously a cost associated with having a um, a lawyer prepare an enduring power of attorney for you, and also for some people, even contacting a lawyer, making an appointment can be a little bit intimidating. So that requirement has been eliminated. Now, getting down to the business of making an enduring power of attorney for a client, one of the things that uh, you're going to have to deal with some of the time is the capacity of the donor. So, for the lawyer making an enduring power of attorney for any client, they need to assure themselves that the donor has capacity. And capacity is often an issue. I've written down lawyer under pressure because I myself, and I know every other lawyer has occasionally felt pressure to make an enduring power of attorney for an individual where they themselves have doubts about the donor's mental capacity. I've had a number of calls in the past, and I'm sure every other lawyer has as well that does this kind of work, is that they're called by a spouse or by an adult son and daughter, and they say, Mom or Dad's in hospital, and they I need to look after their banking, and they need to make an enduring power of attorney, and you come and help. And I have. Sometimes I've gone to one of the continuing care facilities, or I've gone to the hospital and I've spoken to the person. And after speaking to the individual after a few minutes, I realized, one, either the total driving force behind making this document is actually that spouse or that adult son and daughter. And that, in fact, not only does the person not want it, but that they don't understand what it is that is needed. They don't actually have mental capacity. Now, I'm going to mention that under our legislation, that capacity is presumed. So, what Section 4 of the Enduring Power of Attorney Act says is, unless the contrary is demonstrated, an adult is presumed to be mentally capable of understanding the nature and effect of an enduring power of attorney. That does not in any way abdicate lawyers of their responsibility of making their own inquiries and determining for themselves. So I typically will go in if I get any sense early on that there might be an issue about capacity, I'll ask them a series of questions. I usually ask if it's not the person, if it's not the donor who's contacting me, and often it's not. Often it is that adult son and daughter, or it is a spouse who's contacting me, and I will always ask, is there any issue about mental capacity? And particularly if they say that they're yes, or if they say, well, mom has good days and bad days, then I'll make those inquiries. Importantly, mental incapacity or infirmity, which is a term that's used in the legislation, is not defined in the legislation. And I've put the BC legislation defines, it's not our legislation, but it is legislation that I look at sometimes because I do find it helpful. I'm talking about helpful for me as a lawyer. So this
Sorry, sorry, no, I think it might be useful for those of us, I see a number of people whose background is criminal law in the participants. So this is something that comes to mind. Is as you might know in criminal law, it's a fairly, I would say a fairly low, loose test about mental capacity, about mental fit,
yes, like fitness to stand trial.
fitness. And I'm just kind of wondering what the questions might be here because my mind with something like this would be like if I was to go up to Copper Ridge and sign a certificate, and someone was able to say this is so blank can help me with my banking while I'm in here, to me, and this makes sure they can handle my affairs. What it does, this kind of tells me that that's mental capacity, but I don't know how the test might look where it's something as potentially onerous and as an enduring power of attorney. So I just thought that might be of some help to people who might be in a position on these?
Okay, I'll start out by saying that that term generally, mental capacity, there isn't one test for everything. So, Bruce, you've touched on that, but it turns out that mental capacity needed depends on what it is that you're doing, and that at law, there's one test for making a will, there's one test for making an enduring power of attorney. It really comes down to the kind of decision that's being made, what the level of understanding that is needed. And that is one of the challenges that we have to deal with. So there is a kind of a very general standard in the Enduring Power of Attorney Act, which is that the person, the donor, understood the nature and effect of the enduring power of attorney. So that's the very basic term, is that the donor understands the nature and effect of the document that they are going to sign. Um, but that is, from my point of view, that's so general and non-specific that I find it really helpful, especially in what I'll call the marginal or gray cases, to break it down a little bit and think about what it is that they need to understand. And that's why I myself often refer to the British Columbia legislation. And it is, I'm going to point out, for a lawyer, if you're acting as a witness to an enduring power of attorney, the lawyer has to sign a certificate of legal advice, and that's one of the statements. There's a number of statements that are referred to in the legislation that have to be included, and that's one of them. That the donor attended before the lawyer providing a certificate, that the donor appeared to the lawyer to understand the nature and effects of the document. And then it goes on. It is very general. I wouldn't My own view is that it's written in such a way that it's not holding lawyers to a particularly onerous standard. Having said that, I think lawyers should be concerned about potentially being sued if there is a financial abuse by the attorney in particular, that they could be sued by somebody else if somebody else comes forward and says, no, mom or dad didn't know what she was signing when she signed this enduring power of attorney. So I do think it's something that lawyers really need to be cautious about. So this is a little clip from the British Columbia Enduring Power of Attorney Act. To be very clear, this is not what the law is here. I find it a useful tool if I'm dealing with a donor and I'm not feeling super confident about how much they understand what it is that I'm telling them. And then I can go through this list of things that are in the BC legislation for making an enduring power of attorney. So this is for every lawyer. They make a decision about whether they want to do this or not. For myself, if I have any doubts that somebody has mental capacity, I won't do it for them, even though I know that that's potentially a big burden for a family. If somebody needs somebody to look after their financial affairs and doesn't have it, it's a big burden. Having said that, I do not myself as a lawyer want to be making and witnessing an enduring power of attorney for somebody where I don't feel very confident that they understand what it is that they're doing. So with this list, in British Columbia, again, not the Yukon, but this is the British Columbia list, the adult has to be capable of understanding all of these things: the property the adult has and its approximate value, the obligations the adult owes to the adult's dependents, that the adult's attorney will be able to do on the adult's behalf anything in respect of the adult's financial affairs that the adult could do if capable, except make a will, subject to the conditions and restrictions set out in the enduring power of attorney, that unless the attorney manages the adult's business and property prudently, their value may decline, that the attorney might misuse the attorney's authority, that the adult may, if capable, revoke the enduring power of attorney, and any other prescribed matter. I want to say that some of these things are put into our legislation in our notes, in terms of the donor has to acknowledge that they understand some of these things, but definitely not all of them. And so I find this a useful tool for myself. So To be clear again, it's not the law in the Yukon. It's just a tool that I myself use as a way to determine if somebody has the mental capacity to make an enduring power of attorney. The requirements for a valid enduring power of attorney are set out in the legislation. They're set out in sections 2.01 and 3 of the Enduring Power of Attorney Act, and they're pretty clear. I'm listing them in short, abbreviated form here, but they are all expanded on, as particularly in section 3. The donor must be an adult and mentally capable of understanding the nature and effect of the enduring power of attorney. It must be in writing, it must be dated. The power of attorney says it will endure despite subsequent incapacity of the donor. So that is what makes it enduring rather than a regular power of attorney. It must incorporate the explanatory notes. I did not reproduce those here and should have. They are they're in the Enduring Power of Attorney Act. It's the very final page of the Act, and they are a list of notes that must be included in every single Enduring Power of Attorney. And so you just copy and then paste them into the document that you are using. The Enduring Power of Attorney can either be witnessed by two people, and those two people must meet certain eligibility criteria, which are listed in section 3.03 of the legislation, or the enduring power of attorney can be witnessed by a lawyer, and that lawyer must provide a certificate of legal advice. And the legislation again sets out what must be included in the certificate of legal advice. For a valid enduring power of attorney, each attorney must also meet certain eligibility requirements. So the witnesses have to meet the eligibility criteria, and the attorney does as well. And the attorney themselves must understand the responsibility and consent in writing to the appointment. When I was going over this morning, I realized that I had missed a couple of things that were in the that I should have mentioned. They're not in the PowerPoint, so I'm just going to mention in terms of the eligibility requirements for witnesses are relatively simple. They're similar to what the eligibility requirements for wills. They have to be not the attorney, not the spouse of an attorney. They have to be adults. For the attorneys, there's those requirements, but there are additionally some requirements about the upstanding nature of their character. So they have to be people that, for example, have not been convicted of fraud in the previous 10 years. They can't be undischarged bankrupts. I'm just going to refer to the legislation. It's person must, so this is for the attorney. The person is not an undischarged bankrupt. The person has not within the last 10 years been convicted of a criminal offense for which they have not been granted a pardon or for which a record suspension has not been ordered related to theft, fraud, or breach of trust. And those things can be waived. If they're acknowledged, they can be waived by the donor.
So perhaps a simple question here or not. An anonymous attendee asks, what is the current state of discussions regarding allowing remote witnessing by lawyers? And I guess, if there's difference for lay witnesses, that might be useful as well.
There aren't any, there's no provisions in the legislation that would permit that. So it does need to be signed and witnessed in person. And I'm going to say I would recommend that in any case. I think particularly if it's a lawyer is the witness, that being in the same room and talking to people and getting a sense of what their mental state is really important to being a witness. And what the legislation is, what it says specifically is that the donor attended before the lawyer providing the certificate. So I do interpret that to mean that they have to be in the same room, so not remotely.
Thanks. And I mean, I guess the other thing that comes to my mind in that is that oftentimes, if I go up to if I was to go up to say to Copperidge with a family member, I'd ask them, when I'm asking the questions to mom, I'd like you to be out in the in the corridor, so I know they're not coaching. They're not. There's no coaching, and on Zoom it's
Yeah,
going to be a lot harder for someone to do it. Okay, we've
that
got.
is, sorry, that is, I'm going to say that that is an issue that comes up quite often that, and sometimes you have to feel sort of almost rude because, you know, this very elderly person is with their spouse or their adult son and daughter, and often they've gotten into the sort of practice where the elderly person says almost nothing, and their adult son or daughter is interpreting that to the lawyer, and you have to put the other person out of the room and spot and talk one-on-one alone to the individual. And that's, I probably don't need to tell anybody that's got elderly parents or grandparents that that can be a challenge some of the time, if you, especially if you're talking about somebody where perhaps they've had a stroke and they do have the mental capacity, but communication is an issue. There's lots of reasons why that can be really challenging. Nevertheless, in my view, it needs to be done.
And we have a bit of a comment or a question from Noel St. Clair. Lenora, you may want to say something about the potential importance of legal advisors making clear, comprehensive notes of their own assessment of the donor's mental capacity and the basis for the assessment, location, presence of others, nature of discussion, questions asked by the legal representative, summary of the donor's answers and demeanor, etc. The cases where capacity is challenged by family members in conflict with each other can often involve judicial considerations of evidence from legal representatives who acted for donors.
That is an excellent point. And as I mentioned before, as a lawyer doing this kind of work, I am conscious of the fact that I myself could get sued if I've made a mistake on something like this. And in particular, if I've let somebody sign an enduring power of attorney who didn't have mental capacity or didn't clearly have mental capacity. The in any of these marginal cases, either because maybe there's some mild dementia, or if there's communication issues, then it's really important for the lawyer to take good notes and note down what questions you asked and what answers you got to it. If you saw the person more than once, where you saw them, if there were other people in the room, keep notes of all of those things so that if there's ever a challenge, hopefully there never will be, but if there is a challenge, that you'll be in a position to demonstrate that you took reasonable steps to determine that the individual had capacity.
And I think it's something good for donors to know if they do have some conditions where it might be challenged. Just listen here is just like, you know, I think given my situation, I'd actually ask a lawyer to do a more formal assessment for the record in case someone said, "Oh, Bruce is autistic." I'm going to challenge that because I don't want X controlling his affairs now that he's incapable. Even though it might be quite obvious to a lawyer immediately that I'm just like, we might want to do a little bit extra just in case because of my situation gets challenged. Anyway, just something I thought about.
That could well be. Um, as I mentioned before, there is this legal presumption of mental capacity, and I think that that is intended to offer some protections, but I wouldn't rely on it too far. And I would say in any case where there might be any question, or even if there isn't any question, write down what conversations you had with somebody. And particularly, as I mentioned before, often uh, the requests that I get are coming through a third party, so they're not coming from the donor. The majority of the time, they are coming from the donor, but quite often as well, they're coming from a spouse or an adult child saying, my mom or dad or my husband or wife needs this document. So rather than the donor asking me, it's this third party. And in those cases in particular, since a lot of the regular communication will be with the contactor rather than the donor. When it comes time to meeting with the donor, you probably want to have, for me, I try to have one or two phone calls with them, and at least one, but more often two meetings with them if possible.
Yeah. And just a question from Darcy Kachuk. On Noel's point, a checklist with standard capacity and questions and recorded answers on file is probably a good practice. I think I might take out the word probably, just straight out, it's a good practice. Perhaps someone has one that could be shared.
That's a good idea. Yeah, I haven't got that specifically, and if someone did, it'd be good to look at it. But yes, yeah, uh, there's some sort of standard questions that you can ask people. I can remember this is really diverging, but I remember a few years ago when I was asked, one of my standard questions is to ask if somebody knows who the prime minister is. And the answer that I got a few years ago was Trudeau. And yes, it turned out that he thought that it was Pierre Trudeau was the prime minister rather than Justin Trudeau. And I did decide that that individual did not have the capacity to make an enduring power of attorney. So, assuming you've gotten over the capacity hurdle, then there's a number of decisions that donors have to make. Most of them are pretty simple, but they all require a lot of thought. This is such a powerful tool and gives so much authority to the attorney once it comes into effect that it is really important that donors think hard about the decisions that they are making. So a donor has to appoint at least one, but they can appoint more than one attorney. And that's I say attorneys or alternates because you can have situations where the attorneys are acting together, uh, or you can have them act successively as alternates. So the multiple attorneys can act successively as alternates, jointly or jointly and severally. Uh, the the jointly and severally, it's interesting. That's the kind of thing that it's actually in the proposed form that people have to choose between these different options. And of course, I think even a lot of lawyers are maybe a little unclear in what joint and several means. Most people don't know what it means. It means that one person can act or two people can act together. And it's a good option, especially if one of the attorneys is outside of the Yukon. Among the decisions, probably the single most important decision for a donor after who they're appointing as their attorney is when they want their enduring power of attorney to come into effect. So I'm going to say right off, when I am making enduring powers of attorney for people, I always say, I hope this never comes into effect. I hope you never need this. And for many people, they never will need their enduring power of attorney. It's not like a will. Everybody's going to die eventually. A person who needs an enduring power of attorney is somebody who gets to a point where they're not able to manage their own financial affairs, either for mental incapacity or something else. But they're still alive and they still need their affairs to be managed. And for them, it needs to be clear when it's going to come into effect. An enduring power of attorney can be brought into effect immediately. I don't do it very often for people, but sometimes. And in particular, if someone is very sick or very old or very infirm. All of those situations, I've made enduring powers of attorney for people that are in their 90s, they're living in continuing care. They still have mental capacity, but they cannot physically do anything for themselves. And that's a good situation to have the enduring power of attorney come into effect immediately. More often, though, they are springing, meaning that something has to happen and to trigger them. So if they're springing, then what is going to be the trigger? There is a default trigger, which is the donor's incapacity or infirmity. Here we go. Sorry. In the next paragraph, section 6, this is Section 6 of the Enduring Power of Attorney Act. It says an enduring power of attorney may provide that it comes into effect at a specified future time or on the occurrence of a specified contingency, including but not limited to the mental incapacity or infirmity of the donor. So I would consider that to be kind of the default, and that is one that is used frequently. But you can pick something else other than that. And the one that, in fact, I myself commonly use is unable to manage financial affairs. But this is one of the decisions that a donor has to make for themselves. Unable to manage financial affairs, I like because it covers not just mental incapacity, but some people get to the point where they can't look after their financial affairs. They still have mental capacity. I'm going to use my own friend's situation. I have a very elderly neighbor. She's actually 98 years old. She's living in continuing care now. She's not able to manage her financial affairs. She's immobile. She cannot easily leave her continuing care facility. Her handwriting is very poor, her eyesight's very poor. She needs somebody to look after her financial affairs. There isn't any doubt in my mind. But she's not incapacitated. And so that is the sort of situation that I would say is one that someone might choose. Lots of people will never be in that situation. As I've mentioned before, lots of people are going to be both physically capable and mentally capable up until very shortly before they die, and they'll never need an enduring power of attorney. But especially nowadays when we're pretty good at keeping people alive into their 90s, sometimes into their hundreds, and but they are typically losing some of their mental faculties slowly over their final years. Sometimes they're becoming very physically incapable, immobile, and so there's for many people they will need to have an enduring power of attorney. It needs to be one of the decisions that's really important is that they decide how and when they want the enduring power of attorney to come into effect. Section 7, I've mentioned here, release of confidential information by healthcare professionals is authorized to address the issue of capacity, which is helpful because somebody has to make a decision about when somebody's incapacitated. And sometimes they need specific evidence about what that is.
Lenore, two questions. I know I missed this one for a bit. Lenore, from George Filipovich, Lenore, in your practice, you probably have a template, an enduring power of attorney template. Have you ever modified your enduring power of attorney template since the new legislation came in force? And if so, what changes were absolutely necessary?
I'm going to say yes. And I'll talk about that a little bit more. I am cautiously optimistic that the form will be published within the next few months. But having said that, I think that what lawyers will want to use will actually probably be a fair bit more streamlined than the form. So the form the drafting of which I was involved with, is really intended for non-lawyers, and it's intended for people filling it out by hand, and similar to the advanced directive form that was published by the Yukon government a few years ago. I think that for lawyers making a form that they will be wanting to modify it somewhat, and that is what I've started to do, is to modify it. The I had been making enduring powers of attorney before with a pretty short, straightforward form, and the main difference with the new ones is that there are a number of sort of new requirements. So new requirements for the witness eligibility criteria, for the attorney eligibility criteria, but also there's some notice requirements that the donor can say in the enduring power of attorney that they want somebody other than the attorney to get notice if it's brought into effect. And so I think properly all of those options should be added to whatever form you're using.
Okay, and another question here from an anonymous attendee. I'm not sure I'm totally understand the downside of making immediately effective enduring powers of attorney stored in the donor's office, stored in the donor's possession or within the law office.
For that, it still means that somebody has to make a decision. So in some ways, I don't see it as being that much different. It's just who's making the decision. So say I make an enduring power of attorney for somebody and it says that it's effective immediately. And they say, I want you, Ms. Morris, to store that in your office safe until I need it. Their instructions first have to be really clear to me what constitutes needing it, and, on what point I can release it to the attorney. But it means I have to make an decision or an assessment that about whether that is met or not. So it doesn't really get around the fact that somebody has to make a decision about when the enduring power of attorney should come into effect, and that they are so that the donor can say, these are the criteria, these are the conditions where I want this enduring power of attorney to come into effect, and but they if particularly if they're saying it's mental incapacity is what's going to bring this into effect, somebody still has to make that assessment of that eventually.
Thank you. And that's, I think we're caught up. We're all caught
Okay,
up on questions now.
great, thank you. Decisions for donors, and then more decisions for donors. So one of the new requirements under the amendments is notice if the enduring power of attorney is activated. So this is actually, I think it's a good one. It's a good protective rule that was put into there. So I'm going to use as an example, if I make an enduring power of attorney, I'll use myself as an example. I have two children, but say one of my children lives in the Yukon and one doesn't. I appoint my child that lives in the Yukon as my attorney, and I might say, and I'm saying that it only comes into effect if I need somebody to manage my financial affairs, if I'm incapable of doing it, or if I've lost mental capacity. The I might say my son who lives in the Yukon is going to be my attorney, but he has to notify the other son. And that means that the other son has an opportunity to, one, know what's going on, and but also to observe what the conditions are, what were met. So uh, what it says in the legislation is where an enduring power of attorney comes into effect or is brought into effect on the occurrence of a specified contingency, the attorney must provide notice in accordance with the regulations to each person, if named in the enduring power of attorney, as a person to whom notice must be provided that the specified contingency has occurred and the enduring power of attorney has been brought into effect. So particularly if the specified contingency is mental incapacity or my inability to manage my financial affairs, then the attorney has to notify this other person on it, or it could be several different people, that this specified what the specified contingency was and that it has occurred. And that does give potentially somebody the opportunity to challenge the whether or not the specified contingency has occurred. I'm going to mention that there are regulations. So there's new regulations. They're very short. They're limited to a couple of subjects. They're primarily of interest to attorneys rather than to donors. And in section 6 or subsection 6, which I've got on the screen, it says an attorney who is required to provide notice under subsection 5 does not have the authority to act until notice has been provided in accordance with that subsection. So I consider that really important. So the uh, the triggered, the specified contingency has occurred, and this is the attorney recognizes that. They actually have to make a written declaration that the specified contingency has occurred, and then they have to send notice. And the notice under the regulations mean that it's I'm not going to go through it, but uh, in terms of sending out, registered mail, some other notice has to be sent certain ways, and it has to there has to be there's sent in a way that the attorney can feel quite confident that they've been delivered. Information with notice is a sort of, sorry, did you have a question?
Yes, yeah, sorry, we've got about three
Okay.
questions that just came in.
Mhm.
So Darcy Kachuk asks, indeed, consider the situation where a donor comes back and instructs a lawyer to have their enduring power of attorney released, but no longer has the capacity to provide that instruction.
If they don't have the capacity to make an enduring power of attorney, then they wouldn't have the capacity to revoke it either. And if the trigger was their mental incapacity, then the enduring power of attorney should be in effect at that point. And there's still these sort of steps that need to be taken. But yes, if they don't have the mental capacity to make it, they don't have the mental capacity to revoke it either.
Leslie McRae has a bit more of a comment, but I'll read it because I think it's very useful
Okay.
information.
Yeah.
There isn't a checklist for determining mental capacity because each individual has different circumstances that the lawyer has to explore. There are also considerations of special circumstances, elderly people with neurological conditions, people with psychiatric disorders, people with intellectual disabilities, for example. Ontario has the best, in my view, guidelines for conducting capacity assessments. It includes an appendix with sample interview questions, re property, re personal care, re decisions, etc.
That is excellent information. So thank you, Leslie, for bringing that to our attention. Yes, I will definitely echo that it is an individual thing that has to be adapted to the individual, and it's good to know that Ontario has a good checklist.
An
So,
anonymous attendee, sorry,
sorry, go ahead.
an anonymous attendee asks, is a bank teller, for example, required to see a proof of notification if the notification is required under the terms of the enduring power of attorney?
I'm going to say this one is a tricky one because banks make their own rules. And in fact, for any lawyer who makes enduring powers of attorney, and for many people who are attorneys, banks are a source of frustration because they make their own rules about what they accept and what they need to see. Um, a couple of years ago, I'm going to go back to Leslie McRae when she was the registrar of the land titles office and made a decision that the land titles office did not need to see the sort of proof that an enduring power of attorney had been brought into effect. And as simply because it's such personal information. And I remember at the time thinking that's really good. For banks, unfortunately, they often will ask for it. Undoubtedly, the information has to be put into writing, but whether or not an attorney is required to show that information is going to come down to the individual institution that they're dealing with.
Yeah, I'll say that's my experience having acted for my dad is that banks were the ones that want to see everything,
Yes.
for a little transaction to put a little money on my dad's account at Copper Ridge and then land titles. We decided in consultation with the lawyer that yes, we want to remove my mom after she passed and then put me on as joint tenant with my dad, and they didn't need to see a lot less
Yes.
than the bank, which kind of fascinated me. Another kind of question comment from Noel here. If in doubt about a client's capacity, a lawyer may want to tell the donor they required an opinion from a physician, general practitioner, or other independent assessor, i.e., IEG psychologist at the front end of the process to confirm the capacity and independent decision making. The lawyer can then provide a request letter to the physician psychologist, outline the legal elements of capacity, e.g., orientation to police time, understand the scope of the estate, understand the extent of the authority, the donor's proposed delegation to their attorney, exploring the possibility of family members duress, dot 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 dot.
Yes. I mean, all of that, those are all options. So I'm I think that for the most part, lawyers are going to be making their own inquiries, asking questions, and coming to their own determination. But in cases where it's not clear, and in particular if there's a high need for the enduring power of attorney to be made, then this is another way of getting information and sort of providing evidence for yourself and potentially to protect yourself uh, if there's any challenge in the future.
Yeah, I think on that one, I'd be more inclined to rely on it to rebut than to confirm. Like again, using the Copper Ridge example, if I went up and the nurse and as going in, the nurse said, I really don't think he's at all capable of signing of any legal documents. I would take that as done to significantly rebut the presumption of what I
Absolutely.
get in a 5-minute visit
Yes.
versus me coming out of there saying, I really have doubts, and the nurse said, oh, he's absolutely capable of signing it. Yeah.
And when you're dealing with family members, it's often on the one hand really helpful because they are spending much more time with this person who they already know and often are in a an infinitely better position to assess the situation than the lawyer is coming in with a client that they've never met before. The catch is with family members is that they also are interested in the outcome, and that for if they're looking at a situation where potentially they're going to have to make an application for guardianship and incur thousands of dollars in cost associated with that, as opposed to, influencing the lawyer in favor of finding that mom or dad does have capacity. I think you'd have to be really aware of that. I've had family members basically beg me to let somebody sign an enduring power of attorney because they knew how difficult it was going to be for them to, if the person didn't make one. So it can be a tricky situation. And I've talked about all these horror stories, but I want to point out that many, many people make these when they are in their 40s and 50s and 60s and there isn't any issue at all about capacity. I'm talking more about the kind of some of the marginal cases because those are the ones that are the more challenging and where more guidance is needed. But the majority of people, majority of my clients making enduring powers of attorney, there isn't really any issue at all about their capacity, thank goodness. Shall I
Thank
go
you.
on?
Yeah, no further questions this time.
Okay. One of the other, so the information with notice, this is one of the other things that's in the new amendments is that in addition to the attorney providing notice to other individuals that the EPOA has been brought into effect, the donor can say that they want financial information to be shared with that other person. It's an option. It's not mandatory, but it's an option. And it might well be one that I see it as useful. On the one hand, it's an invasion of privacy. On the other hand, it could be very useful as a check and balance, like put somebody else in the position by giving them information that they would be able to assess whether or not the attorney is acting honestly. And my last line on this slide is check the regulations. It's mainly for attorneys. It is mainly information for attorneys in particular about giving notice and reporting that they might have to do in the county. Who decides when an enduring power of attorney comes into effect? This is a really important decision. And the legislation makes a default. It's two medical practitioners or a medical practitioner and a nurse practitioner declare in writing that the specified contingency has occurred. When I'm making enduring powers of attorney, I always ask people who they want to make that decision. the declarant, that's the term that's used, does not need to be a medical practitioner, and it can even be the attorney. And lots of people choose the attorney, particularly if it's a spouse. So a wife making an enduring power of attorney might say, my husband's in the best position to decide whether or not I have mental capacity, and I trust this person implicitly and decide that that is the person that they want to do it. And it can be, I'm, as a lawyer, of course, we're cognizant of the fact that there's a innate conflict of interest in doing that. But the legislation leaves it entirely up to the donor who they decide they want to be the one to choose who is who declares when they don't have mental capacity or when they are unable to manage their own financial affairs. The person who's making that decision, declarant, has to make this declaration, a written declaration, that the specified contingency has occurred. And it doesn't say in the legislation, but I would suggest it say in the enduring power of attorney what specific pieces of information have to go into that declaration. The authority of attorney, so back to the powerful nature of this tool, the enduring power of attorney, once it's in effect, allows the attorney to step into the shoes of the donor. So what it says in the legislation is subject to this act and any terms contained in an enduring power of attorney. An attorney has authority to do anything on behalf of the donor that the donor may lawfully do by an attorney and may exercise the attorney's authority. The maintenance, education, benefit, and advancement of the donor's spouse and dependent children, including the attorney. Oops, I cut that off. But if the attorney is one of those, in one of those categories, it can be for that benefit. So direct conflict of interest in this case. This enduring powers attorney generally will list off both some specific things. I always list off banking as one of the things that the attorney can do so that you can show the bank that, yes, this is one of the specific things that the donor has said that the attorney can do for them. But it can be, in general, the attorney can do anything that the donor could do, make a will, unless the donor has said in the enduring power of attorney that they can't do it. So that's perhaps in some cases the more important thing, is to say they can do anything except these specific things. There aren't too many things that they don't want their attorney to do, but selling their house, I'm going to say, is one that comes up from time to time. The attorney has the authority, as it's mentioned on here, to use the donor's money to look after dependent families. The attorney not only has authority to act, they have a duty to act. And this is really important. This is actually different from under a regular power of attorney. And it's also different from an executor under a will. An executor under a will can renounce their appointment. The attorney has very limited ability to renounce their appointment. If the enduring power of attorney is triggered, for example, by mental incapacity or incapability of managing financial affairs, then the duty not only can act, they must act. So what it says in the legislation is if an attorney has acted in pursuance of an enduring power of attorney or has otherwise indicated acceptance of the appointment and the enduring power of attorney has not been terminated, the attorney has, unless the enduring power of attorney provides otherwise, a duty to exercise the attorney's powers to protect the donor's interest during any period when the attorney knows, or reasonably ought to know, that the donor is unable to make reasonable judgments in respect to matters relating to all or part of the donor's estate. So the exceptions to that are, in particular, if there are other attorneys appointed. So if you were the one and only attorney appointed under an enduring power of attorney, you don't have any ways out of it except with the permission of a court. But if you are one of several attorneys named in the enduring power of attorney, then you can get out of it, in particular if it has not been triggered yet. Once it's triggered, you're on there unless you are relieved of responsibility by a court.
The RC Kachuk has a question. So do I understand that if a donor makes a will, then executes an enduring power of attorney, and the enduring power of attorney condition is triggered, the attorney can then make a new will that would nullify the original will?
Wills cannot be made by an attorney. That is one of the exceptions. That's one of, so when uh, where is it? Sorry. Here we are. An attorney has authority to do anything on behalf of the donor that the donor may lawfully do by an attorney. So there are some things that cannot lawfully be done by an attorney, and by probably the most common or the one that's best known is they cannot make a will. In general, they cannot do things that will be triggered by their own death. So that can include things like changing a life insurance designation.
One more quick question from Sarah Overton. Must an attorney be an individual, or could it be a legal person, such as a trust corporation, or I know there's now companies that are selling services to make things better for executives to appoint a company as a state executive, for example. Those type of things.
I'm going to say it has to be an individual, but that is actually a really interesting question that I had never thought of before. Let's see. I'm pretty sure it has to be an individual. Let me look. There's a checklist of requirements for an attorney. Looking through it. I'm going to say they only apply to individuals. So they're in the legislation. I'm aged 19 years or older. I understand the nature and effect of the enduring power of attorney. I am not an undischarged bankrupt. Within the last 10 years, I've not been convicted of a criminal offense for which I have not been pardoned in relating to theft, fraud, or breach of trust. I'm not at this time providing paid personal care. And it's certainly, I don't think it says anywhere specifically in the legislation, but it's clear from the legislation that it's intended to be an individual.
It's certainly reading those terms. It's very much implied that
That's a person.
it should not be a corp.
Yes, yes. I know that trust companies are commonly appointed as executors for under a will, but the enduring power of attorney doesn't seem to be intended to allow that.
And it's certainly if you do something like trying to point your dog is enduring power of attorney act, it should be a trigger for the lawyer to say maybe this person is not capable of making an enduring power of attorney.
Yes, I would agree with that one. Shall I go on?
Yes, go on.
Okay. Uh, there's a number of other provisions in the legislation that attorneys should be aware of. So when you are acting for a donor, which is obviously different than acting for an attorney, but if you're making an enduring power of attorney, then you're acting for the donor. And so you're less concerned about what the attorney's obligations are, but it's still a really good idea to become familiar with them, both because the donor should know what it is that they are taking on. And furthermore, there's a good chance that you're going to meet the attorney, and the attorney has to sign a form saying that they have the consent to the appointment, and that they understand what it is that they're taking on. That is one of the specific requirements for the attorney when they are signing. One of the statements that they have to agree with is, I'm aware of and accept my duty to keep and provide financial records as set out in the Enduring Power of Attorney Act and the donor in the Enduring Power of Attorney. And sorry, missed it, but they have to understand what it is that they are agreeing to. And so for the lawyer, you need to understand what it is that they are committing to as well. Other provisions for attorneys, though, that are, I think, are significant: application to court for advice. This happens more often than you might think. Order that enduring power of attorney is valid. And that's in a case like we've discussed before, where an enduring power of attorney might be challenged. Then you can make a court for an apply to court for an order that an enduring power of attorney is valid. An order that an attorney has authority to act. So that means, has the specified contingency been met? You can apply specifically to courts to ask them to make a declaration that the specified contingency has occurred and therefore that the attorney has authority to act. Uh, Attorneys are trustees. This is really important. So it's not their money, it's not their stuff, and this needs to be emphasized. For most attorneys, thank goodness, it's a non-issue, but tragically for some, it is an issue, and so they need to be aware that they potentially are going to have to provide an accounting. They have to keep detailed financial records. I tell people they have to keep both the receipts and also keeps like a record that they spent this money and also the actual detailed receipt of what they spent money on. They potentially have to either account to a court or to the public guardian and trustee. Order to terminate authority of attorney. I've been involved in several of these so far where it's mostly okay. Sometimes it's a situation where the attorney themselves have lost mental capacity. If you've got somebody appointing their spouse, who's also quite elderly as an attorney, that situation is going to come up. But unfortunately, quite often, a court order to terminate the authority of an attorney is because the attorney's been abusing their position. Somebody can apply to court for an order to terminate that authority. Um, Renunciation is that special situation that we turned to before, where I've mentioned the attorney does not have any particular entitlement to renounce their appointment, except if there is an alternate who's able to take on the responsibility. And the exception to that is they can renounce with the consent of the court. So there's the language: except with leave of the court, an attorney shall not, during any period in which the attorney is required to exercise the attorney's duties imposed under Section 9, renounce the appointment as the attorney.
Just an update on the last question. I looked at the Enduring Power of Attorney Act, and at section 3.232A, it says the a per, and it says, in the case of an individual, they must be an adult and have mental capacity. So certainly think that probably, it's an open question, but I think that's certainly might imply, in the case, if it's an individual, they have to be an
It's
adult
not an
and have,
individual. Yeah.
yeah.
Then that was a particularly good question. I had not thought about that before. But you're right. If it's saying a person is eligible, and it's using person, not individual, a person is eligible to act as an attorney under an enduring power of attorney if A, in the case of an individual, the individual, and then has these different criteria. So the implication would be that it could be somebody other than an individual. So
And
I'm
I'll
going to say
just note,
I learned something today too.
Leslie McCrae agrees with us, and we do have another question from Sarah that I'll just read in. Thanks for agreeing with it with me, Leslie. Sarah Overton says Canadians are more nimble than ever, even as elders. Would the legislative scheme in the Yukon stop an enduring power of attorney from Nova Scotia, for example, work in Yukon if the donor themselves is in Yukon, or does the donor's property have to be in Yukon? By stop work, I mean is inoperable because the non-Yukon power of attorney does not comply with Yukon legislation. I remember, I think there was a case about this last year, but I just can't remember the outcome. But I'll leave it to you to answer that, Lenore.
It is, probably won't be able to put my hands on it right now, but there is a saving provision in the Act which says that if the enduring power of attorney was valid in the place where it was made, then it's valid here. Let's see if I can find that. I know that that is the case, though. And sorry, everybody, take me a couple of minutes and then you take a look.
I mean, I guess the other interesting question would be is I know sometimes it's advised if you hold a lot of property in another jurisdiction, you may want to will in another jurisdiction. So if you go so if I was, for example, to go in to make a will in BC in Vancouver because I own a condo there, and then they did an enduring power of attorney, there might be a question which one applies and where and all of that.
Yes, I'm going to say in the case of a will, I understand that one better because you wills have to be probated in the place where a person lives. But if you wanted to deal with, so if you live in the Yukon but you own property in British Columbia, then you have to have your probate resealed in British Columbia. And it's because the British Columbia Land Titles Office won't recognize the court order from the Yukon. I did find the saving provision. So it says, despite subsection 1, a power of attorney is an enduring power of attorney if, according to the law of the place where it is executed, it is a valid power of attorney and the attorney's authority under it is not terminated. So yes, if you've made an enduring power of attorney in another place, and I know I mentioned earlier that the Enduring Power of Attorney Act that we have here in the Yukon was originally one of, I'm going to say, probably 12 at the time, enduring power of attorney acts that were enacted in Canada based on model legislation. And so that saving provision that we have here in the Yukon, there will be something similar in Nova Scotia, so that your enduring power of attorney made in the Yukon would be applicable in Nova Scotia. Having said that, if you've actually moved, it's much better if you have the one in that place, if for no other reason than because it will look like what banks and other organizations are expecting it to look like.
So it is probably something that's best to hold in your primary jurisdiction of residence
Yes,
and or where the assets are.
yes. But it is, I mean, the legislation is clear that it is, if it was validly made in another jurisdiction, then it's valid.
And if you do go in for for one of those will questions, don't make sure the lawyer doesn't draft up a second enduring power of attorney.
Yes, there's that. So
Anyways, Leslie wanted to thank us both for the presentation. She'll catch the rest later. Thanks.
thank you to Leslie for the information she provided. That's really helpful. I do not know everything, and everybody will encounter different situations that I won't have encountered at some point, and so I'm happy to get more information. So we're currently in this void where we haven't got a published form. That's why I put, should donors' lawyers make up their own EPOAs? So lawyers have been making enduring powers of attorney. Every lawyer that does this has a form that they use for themselves. And going back to George's question from earlier, if he's still on, then I would suggest you can start with your own form, maybe look at some of the additions under the new legislation, and add, in particular, the notice requirement that is associated, but also add some of those criteria, those criteria for witnesses and for attorneys. And I would suggest that they be added into your form so that it's clear that those things have been covered off. Um, I would say that lawyers, despite the fact that we've been sort of cut out of the process because we've been made technically less essential because the legislation is in fact more complex than it previously was, and donors have more options than they did before. I would say that we are needed more than ever to assist clients in making enduring powers of attorney. There are a number of decisions that need to be made. And most of them are optional. I have to point this out. So there's a few basic decisions that everybody who's a donor has to make, appointing who they want to be their attorney, what they want to be their trigger, who they want to be the person to decide what the trigger is. But a whole bunch of things after that are strictly optional. They can have other people get notice or not. They can have private financial information provided to other people or not. The form, when it's released, is going to be not mandatory, which is good. It means that a lawyer can take that form and modify it as long as it still meets the requirements of the legislation. They can improve it as they see fit or streamline it. The form, as I've most recently seen it, is a little cumbersome. It's way longer than the form that I had been using for clients before. And what I've been doing is taking that form and I've just taken out a whole bunch of stuff and put in the more commonly chosen options. Lawyers can create their own forms as they always have, but they should incorporate the new options, in particular about notice. And I would say also the new criteria that are in there for witnesses and for attorneys. And I'm at the end. I'm going to stop sharing. There we go. If anyone else has any other questions,
We
then
we
I'm
we,
happy to answer them.
we have another question from Noel. Lenore, do you have anything else to say about the donor's revocation of an enduring power of attorney? For example, in a case of a transient now resolved issue of acute mental incapacity.
Okay, you're gonna have to read that one to me again. Sorry.
Lenore, do you have anything else to say about donor's revocation of an enduring power of attorney? For example, in a case of a transient but now resolved acute mental incapacity.
Capacity testing to some extent is a point in time thing. So I mentioned earlier that the example of going to see somebody in a continuing care facility and being told, oh yes, he has good days and bad days, he's better in the morning than in the afternoon, things like that. They have to understand what it is that they're doing at the time that they're understanding them, and it doesn't mean that they have mental capacity 24 hours a day, 7 days a week. If at the time that they are executing a document they understand what it is that they are doing, then in my opinion, at least, they have capacity.
I just see something from Glenda. I just wonder, Glenda Murin, if I just wonder if she has a question. It just says two issues in the chat, so I don't know if that was referring to Noel's question or if she has a question. Glenda, please send any questions you have if you do. We'll give it a few. Okay, here. Sorry. One big difference between guardianship and EPA is the authority to sell property. With guardianship, it requires a special section on the application, and the court is sometimes reluctant and yeah, I think there might be something in with the way Glenda's typing. Sorry, Glenda.
That is, I'll just talk for anybody that's still listening there. The guardianship is the alternative. If somebody hasn't made an enduring power of attorney, and if, in particular, if they lose mental capacity and their financial affairs need to be looked after by somebody else, then that somebody else, typically a family member, will apply to court to be appointed guardian. And then there's a whole piece of legislation, the Guardianship Act, that covers that. And the Although I was mentioning that attorneys are taking on a lot of responsibilities, it's even more onerous for guardians, and they have to jump through a number of hoops to be appointed guardian to begin with.
Yeah, I know I had one situation in my family where we had a family member who was in a coma for an indeterminate period of time and had not completed enduring power of attorney. And it was basically like I can't pay your basic bills. Kids might lose their home and all of those things until we got guardianship, which is from what which I understand is a process that seems to be a lot of questions on how it exactly is done in the Yukon.
Yes, the
Yeah.
and I'll rattle on a little bit more about banks. So my 98-year-old neighbor who I referred to recently, who does have an enduring power of attorney, and I'm her attorney, but it hasn't been triggered, and for reasons I won't go into, but I have I've dealt with two banks locally. In one case, she has a personal relationship with one banker, and they've been extremely helpful for us. The other bank has been could not have been less helpful. I, as a general rule, I hate banks. They are extremely careful about protecting their own liability, and but the result is that for family members trying to look after the financial affairs for an elderly person or a person suffering from some mental dementia or something else, um, banks are not your friend. They will, they will do everything they can to block you, it seems.
Like I said, easier to transfer a house than to withdraw $1,000
That's right. Yes.
for corporate expenses, which, and I'm not joking on that. Glenda Murin asks also any signs of a registry for EAPs and wills.
I'm not aware of one, and so the amendments to the Wills Act a few years ago, I think most people know, uh, provided for there to be a wills registry, but I have not heard of there being any budget set up for there to be such a thing. I think it would be a great thing. I mean, we're kind of lucky. The Yukon's pretty small, and so Glenda and I and every other lawyer that does this kind of work gets all of these every week. They get several inquiries about whether or not we have a will for someone. And yes, it would be much better if there was a registry that said anybody that had made a will and where it was.
And lawyers who don't practice in the area get one or two, a couple every 6 to 12 months, saying, Do you have my granddad's or dad's will?"
Yeah. And so, yeah, I haven't heard anything. And it's now been, oh my gosh, it must be, I think it's 8 years now since that legislation was changed
Yeah,
to at least allow for it.
I certainly I certainly would like it just because it's just like it's often people dealing with the most difficult part of their life, and they have to um call around to lawyers to see if there's a will in place, which is not fun. Sorry.
We are at 127, so going to wrap it up. There's one thing that I did not mention, but I was triggered by our conversation there. Um, if a donor wants their attorney to be paid, they have to say so in the legislation. There is no, if it does not, sorry, they have to say so in their document. If they do not say that they want to compensate their attorney for their services and specify how that is to be calculated, the attorney will not be entitled to any compensation whatsoever. This is such a big job and such an important job that any lawyer acting for a donor should encourage them to compensate their attorney. Unless it's a spouse, anybody else should be compensated for taking on
And
this job.
and just one last, hopefully quick question: is there anything we can do to remind banks that CTCs, which I'm not sure what that is, of the enduring power and attorneys are not rendered invalid by the subsequent expiration of the notary's license?
Oh gosh, I haven't encountered that before, but it just wouldn't surprise me because banks will do anything. Um, yeah, I actually had big argument with a lawyer for Royal Bank a while ago about an enduring power of attorney that I had prepared for somebody. This is before the changes to the legislation, and even though the legislation is really clear what the requirements are for a valid enduring power of attorney, they just didn't like the look of it and refused to accept it. So yes, it would be good. It would be good if banks were a lot easier to deal with, but unfortunately, they are their own bodies and they make their own rules. So
Yeah.
we're at the end of our time.
Yeah. And so thanks, Lenore. Thanks, Lenore. And Noel also thanks us for the presentation and the time invested for in the clarity of your presentation. So thank you, Lenore. The Law Society thanks you, and we look forward to everyone join us for the next CPD, which I'm not sure what's up next, but you'll certainly get those messages, and we're always happy to provide these, and always if anyone sees what's necessary in coming outreaches, and certainly if you have something to share, like Nora did, it's amazing if you just just call up the Law Society, and more thank yous coming in, which is always great. Just send a message to the Law Society, and we will work with you to provide it. So, on behalf of the Law Society of Yukon Continuing Legal Education Committee, I thank Lenore for her presentation and thank everyone for attending. Thank you.
Thanks, Bruce. And I hope that was helpful. And I'm happy to say that I learned a few things from the commenters today, as is often the case. So thanks for that. And everybody have a good afternoon.